All right. Good afternoon, ladies and gentlemen. My name is Judge Law, and we are going to begin with our state expedited accusation calendar for today, February 14th at 2 p.m. with the State Court of Fulton County. These are new arrests in which individuals were recently booked at the Fulton County Jail. Soon after being booked in, their cases have now been formally accused by the prosecutor, who is the Solicitor General of Fulton County. I will let the defendant know what their new case number is, what are the charges brought against them, to appoint counsel where necessary, and also to set a bond. If you're a defendant, oops, I see more people are coming in. Okay, while we're waiting for the folks to get seated in courtroom 2, for those of you who are appearing on Zoom, if you are a family member, a victim, someone here who wants to speak on behalf or against a defendant, please switch your video off and keep your screen on mute. Switch your video off and keep your screen on mute. You may chime in when you hear the particular defendant that you want to address. So unless you're courthouse staff, switch your video off and keep your screen on mute. Thank you. As I was saying with regards to the cases for individuals in courtroom 2, these are newly accused cases. So when I address each of your case, I will let you know what's your new case number, to appoint counsel, set a bond, as well as to provide you with a court date. With regards to bond, we'll be looking to see if you have a criminal record history, as well as review the warrants and the pleadings in your case to determine whether you qualify for a signature bond, which you would not have to pay for today, but you'll have to comply with certain conditions, or you may possibly receive either a cash bond or a surety bond. For the latter, you would have to pay for your bond either out of your own pocket or through a bonding company. Please remember that as a defendant in a new misdemeanor criminal case, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. Courtroom 2, who shall we begin with?
Your Honor, we would need a Spanish interpreter today.
Let's see, Mr. Chate and Ms. Harris, or Ms. Morris. Is Ms. Morris with the PD or ASG's office? I think she's with the ASG. Okay, thank you. Mr. Chate or Ms. Harris, do y'all need a Spanish interpreter for any of your cases?
Thank you.
I don't for any of my cases, Your Honor, and I just wanted to note that Mr. McLean's running about 20 to 30 minutes late. He had to change a tire on his car. So
Okay, we'll wait for him.
okay.
And what about you, Ms. Harris? You okay? You don't need an interpreter?
Your Honor, I'm letting them know for the bind over, they will need a interpreter.
Okay, yeah, we'll wait for that. Mr. Ortiz Gomez, yeah, we'll need to wait for that. Okay. Meanwhile, can we address any of Mr. Chate's cases or Attorney Harris's case? I think she's got Kellen Kidwell.
Okay, she's saying attorney. Okay.
Yes, Your Honor. I represent Ms. Tanaya Harris, who's the defendant there. We are ready to proceed. I do have several witnesses who I've observed online with their cameras off. So we're ready when the court's ready.
We're ready, Your Honor, with position number 4.
This is Tanaya Harris, accused of simple battery and disorderly conduct from February 6, 2025. Her accusation number is 25 CR 000774D. Ms. Harris, you've been advised of your right to remain silent, and your attorney is going to be Ms. Kidwell. Any priors?
No, Your Honor.
Ms.
Oh,
Howard?
sorry.
Third arrest, 2018, shoplifting dismissed. 08, shoplifting dismissed.
All right. And let's see, is it Ms. Mukeke? Ms. Mukeke?
Yes.
What's the recommendation for Ms. Harris?
The recommendation for Ms. Harris is a signature bond. Stay away from that incident location. No further contact with the victim in this case, Yasaris Fuentes. a day or so of anger awareness, no drugs, weapons, or alcohol. In this case, the victim told officers that the defendant had verbally and physically attacked her over a parking spot at the gas pump. They both tried to pull up to the same pump, and the victim relocated to another one. The defendant approached her on foot and began to berate her, calling her racial slurs. The defendant then knocked the victim's cell phone out of her hand. When the victim pulled out her cell phone to record, the defendant then fled the location. The victim did show officers video footage of the incident. Our office has spoken with Ms. Fuentes, who states that she does not know the defendant. She confirmed the events in the warrant and states that she, of course, wants no contact. I would just ask the court to sound for Ms. Fuentes.
Davila Fuentes, if you are on Zoom, this is the time to unmute and start your video. Davila Fuentes. All right. Ms. Kidwell, any objection to a signature bond with the stay away?
No, Your Honor, we definitely don't object to the signature bond. Just wanted to bring it to the court's attention and to the state's attention that according to my client, she did not flee the scene, but rather this was a one-sided report taken. I did see the information provided by the officer regarding a recording, et cetera. The family is actually here because they went to the gas station to get the gas station's recording. And so it's really important to note, and they really want the court to know that this one-sided report, which as you see, the victim isn't here, has devastated the family and this young woman here. And so we certainly won't be pleading guilty to these charges and hope to work out a resolution with the state. But it's important to note, again, I can't stress enough the fact that there was no fleeing the scene. Rather, there appeared to be some verbal altercation that my client believed was so minuscule, she simply left. And as she was going about her day, was recently arrested.
Well, it'll be interesting what the cell phones show up. But in the meantime, simple battery is going to be 1,000. Disorderly conduct is going to be 500. That's a 1,500 signature bonds for pretrial services, level 1. To stay 200 yards away from the Shell gas station at 5866 Roswell Road in Sandy Springs. So, Ms. Harris, you're not to return to that location, and you're definitely and to have no further contact with Yasiris Davila Fuentes. So, if you identify this person on the street, make sure you stay 200 yards away. You report to pretrial once a month, and please report to court when summoned. You're not allowed to consume any illegal drugs and no firearms. And her next court date will be sent to her current mailing address. So Ms. Kidwell, if you want to go ahead and file an entry of appearance and just make sure that the defendant's address is current with the courts at all times.
Yes, Your Honor. And actually, in response to the court's order, does the court mind also including that the victim isn't to contact my client because they don't
Denied.
know each other?
Denied. She's not charged with a crime.
I mean, presumably because the state didn't ever speak to my client before simply arresting her.
That's how it rolls, Ms. Kidwell.
And does the court not want to hear from the witnesses with
Don't
regard?
need to. She's got a signature bond. If I hear something from a witness and it turns out to be quite negative, you risk the chance of the bond being revoked and amended. So
I understand that.
It's happened in the past. All
I
right.
understand that. My
All
client
right.
is simply afraid of the opposing party as well. So we will address that issue in a different way, perhaps with a protective order.
If she believes she's being stalked by that individual, you know there's always avenues in Superior Court. So
Yeah, absolutely. A protective order. Yes, we definitely will be pursuing that.
all right. Anything else, Ms. Kidwell?
No, Your Honor.
All right. Y'all have a good day. Everyone involved in this case are free to go.
Thank you.
Mhm. Next case, please.
Position number 6, Mr. McGee.
Mr. Chate, that's your client?
Yes, Your Honor.
All right. This is State versus Makey Dejan McGee, accused of battery family violence from February 13th, 2025. Mr. McGee, you've been advised of your right to remain silent, and your attorney is going to be Mr. Chate.
First,
All right. And Ms. Morris, anything to add?
I'm sorry, Your Honor, this isn't my case.
Oh, is it? All right. Is it Ms. Mokeke? I'm sorry, Ms. Mokeke?
Who is this again, Your Honor?
This is position 6, McGee. All right, anyone who's appearing in court for this case, please remove your hat. It's pretty, but it's
McGee?
not allowed in a courtroom. All right. You have it, oh, Miss Allen, whoever's
Yes,
got
it's
it.
mine, Your Honor. I
All right,
apologize.
no problem.
Your Honor, this incident happened yesterday. The incident location is 1940 Fisher Road Southeast in Atlanta. The victim in this case is Michaela McCrary, who is the defendant's sister. The parties were arguing over the key to their mother's room. When the victim refused to give the defendant the key, the defendant pushed her and punched her in the face. Officers did observe visible injuries to the victim's face. Our office has spoken with the victim in this case. She confirms her and the defendant are siblings. They live together at the location. She also confirmed the events in the warrant. She told our office nothing like this has ever happened before. She called the police because she was afraid in that moment. She never wanted the defendant to get arrested. She did state that she is not in fear of the defendant and wants to continue contact. Given that this is his first arrest, the state's recommendation is a signature bond, no further violent contact with the victim, that he undergo an FVIP, no drugs, weapons, or alcohol while out on bond.
Is that satisfactory, Mr. Chate?
Yes, Your Honor. Just
right.
about the FVIP, my client is still in school. He's 17. So wondering how that would work with FVIP. I was wondering if there was a less restrictive condition.
Well, let's see. For the battery family violence, that's going to be a 2,500 signature bond through pretrial services, level 1. No further violent contact with Michaela McCrary, which means, Mr. McGee, you can return to the home, but there cannot be any physical or verbal altercations involving Michaela. Otherwise, if there are any future altercations, unfortunately, the cops will arrest you first and then ask questions later. Do you understand? No illegal drugs, no alcohol, no weapons and firearms. You are to I'm not going to require you to do a FVIP at the present time, but I want you to enroll and complete in at least 12 anger management classes. You're to enroll in those classes within 60 days of being released, and you and or your family need to pay for those classes. You will show proof of enrollment and completion of these 12 anger management classes, and you're to be compliant with all and any medication or treatment that you're undergoing, and you're to be compliant with school schedules and school classes and attendance. All right. Make sure your address is current with the court, and we will see you when we send you your summons. Thank you.
Go to position number 1, Mr. Bass.
Joshua Bass is accused of loitering and prowling from February 12th, 2025, case number 25 CR 777A. Mr. Bass, you've been advised of your right to remain silent, and your attorney is going to be Mr. Chate. How many cycles, Mr.
Eight.
Howard?
Eight.
All right.
Burglary, second degree, criminal attempt to commit burglary, theft by taking, the first offender, and the 2015 probation. Jail is a recommendation.
All right. Ms. Mukeke?
Yes, Your Honor. This incident occurred at 4110 Old Alabama Road, which is Autry Middle School. The defendant is accused of driving his vehicle into the school property at night and remaining there overnight. When speaking to officers, he told several stories, including that he thought there was an exit another way out of the property, and there wasn't, and his car just got stuck there. The state's recommendation is a signature bond. Stay away from that incident location. No drugs, weapons, or alcohol while out on bond.
All right. Mr. Bass, based on the state's recommendation, your bond is going to be set at $2,500. It's going to be a signature bond through pretrial services, level 1. Does he have a current address, Mr. Chate?
Yes, Your Honor.
And where is it?
I don't have the address, but he did tell me that he had a place to live.
Mr. Bass, what is your current mailing address so we can send you notice of your next court date?
It's 740 ARKWITH Way. It's 740 Arkwood Way. That's Alpharetta, Georgia. Zip code 30022.
This is Mr. Bass. That's not the address we have.
534 Woodcrest Manor Drive. And that's Stone Mountain, Georgia.
So you first gave me an old address, now you're giving me a new address?
No, I have two addresses.
You have two addresses. Which one receives mail?
One of them is my mom's house, and the other one is
That's not, which one receives mail for you?
both of them. Is my mail.
All right, we have both addresses there. We're going to send it to the Woodcrest location because that's the current address that we have on the booking. If that is not your correct address, you're required to come back to court and update your address in writing. You are to stay 500 yards away from the Autry Middle School. You're not allowed within 5 football field lengths of that school. You are not to consume any illegal drugs, no alcoholic beverages, and no firearms. You'll be subject to random screens for illegal drugs and/or alcohol. And you report to pretrial services in downtown Atlanta once a month. If you fail to report, if you get arrested again, or if you don't show up to court, your signature bond will be amended to a cash bond or a surety bond the next time. Thank you.
Yeah, see that. Your Honor, we could go to jail court's iPhone. That's gonna be position number 13.
This is Peter Theodore at Jail Court iPhone. Mr. Theodore, my name is Judge Lal. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you presently is Mr. Shatay. You are accused of simple battery. Is that correct? You are accused of simple battery and criminal trespass from February 13th, 2025, under case number 25 CR 779E. Any priors, Mr. Howard?
39, 2022 violation of protection order conviction. 2020 obstructing court order, 2019 FTA, 2018 assault conviction, 2 FTAs from 2018, 2017 contempt of court, unlawful entry conviction, harassment conviction, 2016 telephone harassment conviction.
That's good. That's good. Thank you. Ms. Allen, anything to add?
Your Honor, my understanding is that this gentleman was offered the opportunity to speak to Mr. McLean today, and he did not want to. He wants to represent himself.
Oh, okay.
He's got history out of Virginia, Kentucky, Ohio, and Washington, D.C. His most recent is a felony terroristic threats arrest out of Kentucky in 2023, and you heard about some other issues. In this case, Your Honor, at about between 8 and 9 in the morning at 267 Marietta Street, downtown. That's the Embassy Suites and specifically the Starbucks there at the location. The defendant came inside the Starbucks and was encountered by security officer James Curry, who told him he needed to leave. He'd been previously asked to leave the location, and in response, this defendant became angry and punched the security guard in the chest, knocking him to the ground. There were multiple witnesses present, and it was captured on surveillance. He was taken into custody, and now we are here. There's some concerns about competency, Your Honor, if I'm being honest. We're asking for a $4,000 surety. It does not appear this gentleman has any ties to Atlanta, but in fact has the ability to travel and commit crimes in multiple jurisdictions. In order to stay away from that location, 267 Marietta Street Northwest, regardless of whether it's the Embassy Suites or the Starbucks, no drugs, alcohol, or weapons, and we'd request a social worker visit.
This Mexican President Peter Theodore, I'm Memphis Mexican Vice President Peter Theodore, I'm gonna plead not guilty to.
All right, sir. Mr. Chate, from what I gathered, Mr. Theodore has declined the representation from the Public Defender's Office. Is that correct?
I wouldn't know. I
Excuse
had
me,
a chance to talk to him, and it looks like this is Mr. McLean's client.
All right, let me ask. Mr. Peter Theodore, do you want to be represented by the Public Defender's Office?
no, I have 5 bank accounts that have multiple dollars in them.
Okay,
I don't need to hire an attorney, I just want to set a bench trial, thank you. I'll
all right,
represent.
sir. On the simple battery is 2,000, on the criminal trespass is 2,000. This is a $4,000 surety bond to stay 500 yards away from the Embassy Suites located at 267 Marietta Street, as well as the Starbucks store in that location, and to stay 200 yards away from James Curry. No illegal drugs, no alcohol, and no weapons. And please make sure that you provide the court with a current mailing address. We presently don't have one. And that way, once you make bond, we'll be able to send you notice for your next court date.
Well, hang
Thank
on,
you.
where do I go for court? Where's the bench trial for this case?
The bench trial will be held at the Fulton County State Court, and the bench trial date has not been set. You will get notice when we have it scheduled. Thank you.
Thank you, Your Honor. No further questions.
And, oh, I'm so sorry, Mr. Jordan, what's the reset date for this calendar?
It is February the 27th.
Okay, so Mr. Theodore's case is going to be further noticed to February 27th for the SAP calendar. Thank you. All right, moving on, courtroom 2, who do we have?
Position number 2, Mr. Carrington.
Okay. Kendall Ahmad Carrington is charged with simple battery from February 13th, 2025. His case number is 25 CR 776A. Mr. Carrington, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you, and your appointed counsel is Mr. Chate. Any priors, Mr. Howard?
Second, 2006 battery, that's it.
All right. Ms. Mukeke?
Yes, Your Honor. This incident happened at 6567 Yarborough Drive in Fairborn. The victim in this case is Sonia McClendon, who is the defendant's cousin, I believe. The defendant's mother, Vicky Carey, called her cousin, who is the victim, over to the house because she noticed the defendant was acting irate and different since he was released from Grady, where he was held for MH reasons. Ms. Carey asked the victim to come over and stay the night at the residence in case the defendant became violent, done so in the past. The morning of the incident, the victim and the defendant's mother were making breakfast when the defendant got in the victim's face and threw water and coffee on her. The incident was captured on video. The victim also advised that the defendant mushed her in the face. Our office has spoken with the victim, who confirms that she does not live in the same residence as the defendant. Confirmed the events in the warrant and stated that the defendant's mother called her because she did not feel safe being alone with the defendant. She states that the defendant does have some MH and was having an episode, that he has been admitted to the hospital a few times in the past couple of months due to this. The defendant's mother then got on the phone and stated that the defendant needs help, potentially something inpatient. They are unsure if he is taking his medicine. She states that she is afraid for her safety living with the defendant. And of course, she wants the defendant to get some help. The state's recommendation is that the defendant have no further contact with the victim, that he stay away from the incident location, that he undergo an MHET and remain compliant with any treatment plan, no drugs, weapons, or alcohol while out on bond. I would ask the court to sound for the victim in this case, Sonia McClendon, and also for the defendant's mother, Ms. Vicky Carey, if she is on the Zoom.
Ms. McClendon and Ms. Carey, if you want to add to these proceedings, you would need to unmute and start your video.
You want to go first or you want me to go first? I'm trying to get my video. Okay. Yes.
Please start your video. Your video is blank.
Oh, I have it on. I don't know why it's not recording. Can you hear me?
We need to see you, Miss McClendon.
I don't know what's going on with the video.
Mine too, 1 second.
The video is not working.
That's fine.
All right, I see someone trying to connect Vicky. Is that Vicky Carey? Your audio
Yes.
needs to be connected.
I'm trying to connect as well.
All right. Ms. McClendon and Ms. Carey, you can go ahead and try get one of your videos on, and we can use the audio from the other one, and that would work. But let's go ahead and mute both of them at the present time. Mr. Shatay, do you have anything to add?
What was the bond recommendation, Your Honor?
Oh, we would be all right with a signature bond in this case, given those conditions, the contacts stay away, and that he definitely undergo an MHET.
Okay, it's just gonna be interesting considering he lives with his mother, so I'm not sure how we're gonna go and do that. Mr. Shatay, any
What did he
options?
recommend?
That they release him for the signature bond. I can't get video. I don't know why.
I need to be able to, can they hear me?
If the court is not
Need to
inclined to
see.
do a signature bond, because I do understand if he is living with his mother and he doesn't have anywhere else to go, then we would recommend a $2,500 surety bond.
Miss Grace, yeah, go ahead. All right, Mr. Shatay, that's the predicament we have.
Your Honor, my client informed me that he does have a place to live. It's just that it's in a neighboring house, and it might be difficult for him to have that 200-yard stay away condition. Now, I recall last week that we had a similar situation in a different case where we had neighbors who were told to stay away, but they were within 200 yards of each other. So I was wondering if we can make a similar arrangement in this case where
Certainly.
one person
So-
can be in the house while and the
Where
other.
is this alternative location?
He said it was in a neighboring house. Mr. Carrington, do you have the address?
The one location is neighboring, but there's many other locations across Georgia. That was just for the sake of the conversation.
Oh, okay. Could you give one alternate address where you can get mail?
As far as mail, I don't know the exact address, but I can have that provided at least by the day of court or whatever may be the day.
Right.
I have an email and whatnot. I can get that to you.
All right, Miss McClendon, do you have your video on?
I have it on, but it's not videoing.
You and Miss Carey can leave the Zoom and then try to get back in. And I'm going to.
But she has to see you.
I'll have video chat on, Your Honor. I'll have video chat for the conversation.
All right, thank you. Courtroom 2, we're going to put a pin on Mr. Carrington and we'll address his bond shortly as soon as McClendon and Carey start their video. Miss Carey and Miss McClendon, please leave the Zoom and correct your devices and come back in. Thank you.
Yes.
Next, Your Honor, we go to position number 5, Mr. Hines. Oh, no, Your Honor. My mistake, position number 9.
Okay.
Mr. Price.
This is State versus Tariq Price, accused of willful obstruction of a law enforcement officer from 25 CR 780E. Mr. Price, you've been advised of your rights and your attorney is going to be Mr. Shatay. Any priors, Mr. Howard?
This is Mr. McLean's client.
Hines,
Any ETA on Mr. McLean?
He texted me a couple minutes ago. He said 5 minutes, so he's very close to being on the meeting.
Okay. I'm sorry, Deputy, we can't address Mr. Price until his client appears. Who's got the Spanish interpreter case? Because Miss Lucia will join us shortly.
Mr. Shatay.
Okay. Any other cases for Mr. Shatay?
Yes, we could go back to position 5, Mr. Hines.
This is State versus Darren Hines, accused of the following offenses: driving, hit and run, failure of the driver to return to the scene of an accident, DUI, driving under the influence of alcohol less safe, failure to maintain lane or improper lane change, following too closely, and reckless driving. Incident date appears to be February 9th, 2025, case number 25 CR 786J. Mr. Hines, you've been advised of your right to remain silent. Your attorney is going to be Mr. Chatay. Any priors?
I forgot how many it was, but 2018 ag assault dismissed, 2018 trespass conviction. The last DUI I saw was 04 conviction.
2004 DUI conviction?
Correct.
All right, thank you.
This gentleman has 18 cycles, Your Honor.
Okay, 18 cycles, got it. And what's the state's recommendation?
We're asking for a $3,500 signature bond, no driving without the proper documentation and registrations, no drugs, alcohol, or weapons. This is a 3 a.m. call to a hit and run with injuries at Old National Highway and Godby Road. The victim in this case had been hit by the defendant driving a black Tahoe. He fled the scene, abandoning his vehicle. He actually struck 2 vehicles when they were both sitting at red lights. He was driving recklessly and at a high rate of speed, struck these vehicles from behind at the same time. He continued driving and drug a 3rd vehicle for a distance until his vehicle became disabled. So the only reason he stopped at all was because his vehicle was messed up. Based on information from the victims, the defendant exited the vehicle. He was seen stumbling. He smelled of alcohol and he was unable to keep his balance, and he fled on foot westbound on Godby Road. Police ran the tag on the Tahoe, pulled up the registered owner's information, and both people on scene identified the defendant as the person who'd fled the scene, who's registered to that vehicle. Traffic cameras also viewed and corroborated the accounts provided by the victims. Unfortunately, we don't have information about the vehicle and the victims in the 3rd vehicle that was hit and dragged. She'd been transported to the hospital because of her injuries, so this could be a felony serious injury by vehicle at some point. Officers inventoried the vehicle that the defendant left and found a foam cup near the driver's side containing an unknown clear alcoholic beverage. It smelled strongly of alcohol, as did the vehicle. Thank you.
Mr. Chatay?
No objections.
I'm not quite sure. On the count 3, failure to maintain lane is going to be a $500 signature bond. Count 4 and count 5 are going to be $1,500 each. And that's the portion that's going to be $3,500 signature bond through pretrial services level 2. No illegal drugs, no alcohol, and no firearms, and they'll be subject to random screens. For count 1, hit and run, that's going to be a $2,000 surety bond. For count 2, it's going to be a $2,500 surety bond, and that's going to be a $4,500 surety. Mr. Hines' total bond is going to be a $8,000 split bond, in addition to the no illegal drugs and no alcohol. He's also not to operate any motor vehicle unless he has a valid driver's license, adequate insurance, and proper registration. Anything else to add, Mr. Chatay?
No, Your Honor.
Thank you. Oh, and his next court date is February 27th. Deputy, I'm going to just return to Mr. Carrington, please. Ms. McClendon, please unmute. We can't hear you. If you want to contribute to the proceedings, we need to be able to hear you. Okay.
I just unmuted.
Do you raise your right hand, please? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Mr. Carrington indicates that he has a neighbor's house where he can live, and that Anything else you want to add?
I just want to say that over the past 2 months that I've been here in Georgia with the family, his mental health has escalated and he's gotten more aggressive. And his mom was in fear of being harmed, is the reason why I was called to the house.
The
And I ended up,
allegations is that he threw a hot beverage. Was it at you or at his mother?
no, he poured hot coffee on me.
Is it hot?
Okay. All right. But you don't live in the household, do you?
No, I don't live in the household.
Okay.
But
All
his
right.
mom is also in fear of him.
Understood. Thank you, Ms. McClendon. Ms. Carey, if you want to contribute, you'll need to unmute.
Yes.
Mental health, dementia, respect.
Or you can use Ms. McClendon's Zoom since it's.
No, I've unmuted.
Raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
And Ms. Carey, what is your take on this case?
Okay, I just want to add that I asked her to come to my house because my son had been released from Grady.
Just one second, just one second. Ms. McClendon, mute your phone because you're getting some feedback. Thank you. All right, and so what I'm trying to figure out is are you comfortable with Kendall coming home with you?
My issue with Kendall coming home right now is that he was in Grady Hospital and I felt that he was not stabilized enough. And I saw the change in him. When he actually came home, I noticed that he was still off kilter. And it unfortunately just got worse over the days with him not sleeping, with him up all night, and the way that he was speaking to me on many occasions. I knew that he still was not well. I had asked them to, I asked for him not to come home until he was stabilized. And they kept him the number of days that they could, and then he came home.
Does he have an alternative place to stay that you know of?
She's not privy.
Excuse me?
Does he have an alternative place to stay that you know of?
I don't know of an alternative place that my son has to stay, but I would like to, can I add something or I can talk whenever you want me to?
How long has he been living with you?
My son has lived with me all of his life. My son was diagnosed with
No, I don't need his medical diagnosis. That's
Okay.
private information. So, going back to my original question, are you comfortable with him being in your home at the present time?
I haven't seen him in a few days, but he's called me and he's still upset at the fact that I called the police with his action. I know that it's all relative to his illness. He spoke with Sonia the night she came to our home. She spoke to her the morning of this incident. I came downstairs and sat and had breakfast with Sonia, and he came in and I didn't know now, it doesn't matter whether it was hot or cold. I didn't know of it being hot coffee, but it was a cup of coffee. Actually, I believe it was my coffee that I had started drinking and left on the table. He had been talking with us earlier. He came in from the garage and he just abruptly threw it on her. And after the coffee, he started taking water and throwing it on her.
Okay.
I know that, so that's what happened. And that's why we're here, because I know that my son needs help. I love him. I know that this is not him. He is in a manic state of this illness. And I'm begging for the hospital to please let my son get the treatment and help he needs so that he can get better, because this is a side of the illness we haven't seen.
Thank you, Ms. Carey.
You're welcome.
Mr. Chate, anything else to add?
No, Your Honor.
All right. Mr. Carrington, you have a right to remain silent. Anything you choose to say in open court, your statements can be used by the prosecutor against you. Highly recommend you exercise your right to remain silent.
Your Honor, if I could, she's just not privy to the multitude of places that I can stay. That's the only thing I wanted to add to the testimony that she put.
And I'm sure you will give your attorney one of these addresses from the multitudes that you have. With regards to the simple battery, that's going to be a 2,500 surety bond. No further contact with Sonia McClendon. No further violent contact with Vicky Carey. He's to stay away from 6567 Yarborough Drive in Fairburn, Georgia. And he's to update the court with his new mailing address within 30 days of being released. In the meantime, the court will order a social worker visit, and we will see him in court on February 27th unless he bonds out. Yes, Ms. Carey?
I have a question because I'm very concerned with my son's mental illness. And if he, the court is saying he can go where
That's why I've required him to get a social worker visit to see whether there is any MH issues and whether any treatment options are available.
He currently, Your Honor, I just want to let you know, he does go to the South Fulton. There's as part of Grady, and they definitely need to be involved. I am concerned that him just going astray with whoever we don't know and whatever, and there's nothing on him where he has to be in a facility. This is a very, very serious and scary illness. He's 36 and he has never experienced this side of it. And I'm just concerned that whoever he's going with or wherever, I just want to make sure I feel he's still in this state. And I just want him to get the medical care and help. So
Ms. Carey, I can require him to comply with all MH treatment and evaluation and medication that he's currently undergoing. The requirement is that he has no further violent contact with you, which means that you can keep in communication with him in order for him to facilitate his treatment, okay? He just cannot have any contact with Sonia McClendon, and he needs to stay away from her. And he needs to stay away from this house until he is better with regards to his MH treatment and compliance, okay?
Yes, can I ask one more question?
Yes.
Because like I said, with his condition and he's supposedly on new medication, how is he going to be manned to ensure that he is taking his medication daily?
If you want to come by the jail and speak with the jail psychiatrist or doctor, you're more than welcome to.
So will he be in jail?
I have no idea of his treatment. He will be in jail pending his release on bond.
And how long will he be there?
His next court date is February 27th.
Okay.
Yes, Mr. Carrington, you've been advised of your right to remain silent.
Right. To the last point, Your Honor, I have multitude of places to live, but I need to be able to get my belongings. I have multiple paperworks and filings. Am I able to go to the house or not? Just curiosity.
I will allow a one-time visit with a police officer. The visit cannot exceed 1 hour.
10-4.
Okay.
Your Honor.
So I have a seat in the,
Next case, please.
can we go back to position number 9, the price?
Okay.
Barrington, while you back there, please keep your mouth shut.
Is this Mr. Chatai's client?
No, Your Honor, this is plain.
This is Tariq Price.
Oh, that's right. Okay. Mr. Price is accused of willful obstruction of an officer, case 25 CR 780E. And Mr. Price, your attorney is Mr. McLean. How many priors, Mr. Howard?
I think about 17. Been in custody since November.
That's what I thought. All right. Miss Allen, I've read the warrant. Any objection to $1,000 signature bond through the jail?
Well, Your Honor, if he didn't already have an open obstruction with a good bond of $1,000 related to fleeing from police who were trying to serve an active arrest warrant, I would agree. We'd ask for a surety bond, Your Honor. No drugs, alcohol, or weapons.
Well, I don't think it's going to be a problem serving him right now, but Mr. McLean, anything else to add?
Well, Your Honor, I think this is from October, so it's catching up with him. So we would ask the court to consider a signature bond, considering everything as a whole. But Mr. Price is a person who's 29. He's a high school education. He's got the 24 CR 007-728E, and he has the 25 CR 000-780E, and those are the
Yes,
two.
I'm familiar with the cases that he's otherwise got. $1,000 signature bond through the jail. No
Thank you.
violent contact with law enforcement. Thank you.
And good afternoon. I finally made it.
Thank you, sir. I hope everything's okay. All right.
Well, I was telling Mr. Tataya the proper methodology when one has a flat tire in the front, you have to change 2 tires, not 1. That's why it took so long.
You're the expert, not me. Deputy Francois, we got lady at ACDC?
Yes, good afternoon, Judge Law. I have position number 3, Dotson.
Repeat the number again?
Position 3, Dotson.
Okay. This is Malaysia Dodson, accused of battery, family violence, and simple battery against an individual, excuse me, who is 65 years or older, from September 20th, 2024. Ms. Dodson, you've been advised you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you presently is Mr. Shatay. Any priors, Mr. Howard?
3rd, 2024, criminal damage to property. It just says indicted.
No.
That's it.
Ms. Mokeke?
Yes, Your Honor. I also see a second criminal damage to property, second degree, and a willful obstruction. It looks like that was dismissed. I think she completed pretrial diversion.
Mm-hmm.
The victim in this case is Laverne Burns, the defendant's grandmother. The incident location is 295 Penelope Drive Northwest in Atlanta. The defendant is accused of pushing her grandmother to the floor and throwing a plate at her. The plate hit her grandmother in the face, causing a laceration and bleeding. When officers arrived at the location, they observed the victim had blood on her hands, neck, and shirt, and a laceration above her eye. The assault stemmed from an argument because the victim had asked the defendant to clean her room and separate her laundry. The defendant had been living with the victim because the defendant's mother had kicked her out following a physical altercation where the defendant attacked her mother and her 2 brothers. The defendant's mother was on scene and advised that her daughter does suffer from MH. Our office has spoken with Ms. Burns, who confirmed the events in the warrant, stated the defendant had never been violent with her in the past, that she has moved from this location and now lives somewhere else, and that the defendant currently lives at this residence with her. There has been no violence since this incident. She is not in fear of the defendant and wants to continue contact. The state's recommendation is a $2,000 surety bond, no further violent contact with Laverne Burns, an FVIP, that she can remain compliant with any treatment plans for MH that she is currently on, no drugs, weapons, or alcohol while out on bond. And I would ask the court to sound for Ms. Laverne Burns.
Ms. Laverne Burns, if you're on Zoom, this will be the time to unmute and start your video. Mr. Shatay?
Yes, Your Honor.
I'm going to do a signature bond through pretrial. Do you have anything else to add?
No, Your Honor.
On count 1, it's going to be $1,000 signature bond through pretrial, level 2. On count 2 is going to be a $2,500 signature bond through pretrial, level 2. She is to have no further violent contact with Laverne Burns. She may return to the 295 Penelope Drive if that assisted living facility allows her to live there. I've never heard something like that, but if she's permitted to live there, she can. Otherwise, she'll need to update the court with her current mailing address. She's to report to pretrial services twice a month. And within 30 days of being enrolled, of being released, she will enroll in a domestic violence intervention program where she will need to attend and complete 26 weekly classes at her expense. Ms. Dodson is also to undertake a MH evaluation and submit herself to any treatment within 15 days of being released. So she'll need to go to a healthcare provider and get evaluation and be compliant with any treatment and medication that's required. Her next court date will be sent to her current mailing address. So if she changes it from 295 Penelope Drive, she'll need to make sure she updates the court within 30 days of being released. Thank you.
And Your Honor, the grandmother said that she has moved to a different address, 3020 Delbar Lane, and that is where the victim is currently residing with her.
1320 Delmar Lane?
3020 Delmar Lane.
Okay. Well, Ms. Dotson, within 30 days of being released, make sure you submit your change of address with the clerk's office in writing. Understood?
How do I do that?
You come down to the courthouse and you go to the clerk's office and you file a change of address form.
Okay.
You'll have to report to pretrial anyways, twice a month. So on one of these trips within 30 days, make sure we have your good address.
Yes, ma'am.
Thank you.
Thank you. Position number 11, Satterfield.
This is State versus Monique Satterfield, accused of simple battery family violence from September 21st, 2024. Ms. Satterfield, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. And your attorney at the present time is Mr. McLean. Understand this is her first arrest. Ms. Allen, what's the recommendation?
Your Honor, we're requesting a $2,000 SOB through pretrial and no contact. The victim in this case, Kyle Drayton, in this incident in September of 2024, reported being struck in the face and head. He had no visible injuries, but he reported that he lives with the defendant. The couple has had prior and subsequent to this incident police reports. And so that's why we're asking for no contact. We tried to get in touch with Mr. Drayton today, but we're not successful. If you'd call for him, again, Kyle Drayton. Thank you.
Mr. Drayton, if you're on Zoom, this will be the time to unmute and start your video. All right, Mr. McLean?
Your Honor, there would be no objection to that bond. She does disagree with the facts as alleged, but that's not the point today.
All right, and is the incident location 600 Phipps Boulevard?
It is, Your Honor. That is her address. The subsequent reports that I reviewed indicate that Mr. Drayton doesn't have a key and actually got people to let him in that were a part of security. And so that's why we're not asking for a stay away.
Okay, thank you. The bond is set at 2,000. It's a signature bond through pretrial services, level 1. No further contact with Kyle Drayton. She may return to the Phipps Boulevard location. No illegal drugs, alcohol, and no firearms. You must report to pretrial services once a month, and you are to attend and complete 2 anger awareness classes. Thank you.
Next, Your Honor, we gonna get to go to position number 14, Ms. Victim.
Thank you, Judge.
This is State versus Allison Alexandra Victim, VICTOM. Incident date is July 21st, 2023, accused of theft by taking under case 25 CR 733G. Ms. Victim, you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean. Any priors?
8th, 2020 financial transaction card theft. It was dismissed. 2020 forgery dismissed. 2013 shoplifting. Jail was the recommendation.
All right. Ms. Allen?
Thank you, Your Honor. A warrant was issued back in 2023 as it relates to this case. The victim in this case is Mrs. Gramling. So this defendant came to the Sonic at the incident location to do orientation for a new job. She's on surveillance, taking Mrs. Gramling, who works at Sonic, the manager there, taking her purse. Very shortly thereafter, the credit cards from the victim were being used on the same road to make purchases. She was found and confronted, while in possession of the purse and the purchased items, and those things were removed and recovered. The defendant fled. Warrant was obtained. This is also partially on surveillance. And at this point, we spoke with the victim. She reports that she's no longer working at that location, that Sonic, but that the defendant had spent $300 before she was able to shut her cards off. She had to dispute the charges and she was able to get her money back. But bank cards as well as medication were taken from her purse. We're asking for $1,000 surety, no contact with Mrs. Gramling, and a social worker visit. This is a reset for medical reasons. And I realized I did not get the appropriate address, so I'll pull that, Your Honor. But that's what we're asking.
For the Sonic restaurant?
Yeah, one
Is
second.
that Smorland something?
I think so, but let me make sure.
Okay. Mr. McLean?
Yes, Your Honor. Ms. Victim is interested in a program, and we will be talking with her about a program to help her with other issues. We would ask for an appropriate bond. Thank you.
Bond is set at $2,500. It's going to be a signature bond through pretrial services level 2. She reports to pretrial twice a month. She's to stay away from the Sonic restaurant on Moreland Avenue. In fact, she's to stay away from all Sonic restaurants. She doesn't work at another one, does she?
No, Your Honor.
Okay. Stay away from all Sonic restaurants. No illegal drugs, no alcohol, no weapons. And also no contact with Michiko Gramling, is that correct, Ms. Allen?
That is correct, Your Honor.
Okay.
Um,
Ms. Victim, if you get arrested again for anything else, if you don't report to pretrial twice a month, or if you fail to appear in court, your 2,500 signature bond will be revoked and converted to a cash bond or a surety bond. Thank you.
And that is 1463 Moreland Avenue. Thank you, Your Honor.
1463 Moreland. Got it. Thank you.
We go to position number 12, Ms. Smith.
This is State versus Naisha Michaela Samantha Smith, accused of theft by shoplifting from February 11th, 2025. Ms. Smith, your case number is 25 CR 785F, and you've been advised of your right to remain silent, and your attorney is Mr. McLean. This is a first arrest for an alleged phone charger from a BP. Any objection to $1,000 signature bond through pretrial?
No objection at all, Your Honor. We'd ask for a stay away, and no drugs, alcohol, or weapons. Thank you.
This is a $1,000 signature bond through pretrial services, level 1. Ms. Smith, you are not allowed to return to the BP gas station at 5995 Roswell Road in Sandy Springs. If you return to that location, you'll be arrested for trespass. You report to pretrial services once a month, and make sure we have a good address so that you can come back to court when summoned. Do not get arrested again. Otherwise, if you are, then you need to bring $1,000 with you to jail. Thank you.
Thank you, Your Honor.
Next, Your Honor, we go to position number 7, Mr. Oliver.
Oh, good heavens. I thought it was going to be the same Mr. Oliver we had the other day. But this is a different Mr. Oliver. Keith Oliver, accused of 2 counts of theft by taking, criminal trespass, and loitering and prowling. 25 CR 0000781H. Mr. Oliver, you've been advised of your right to remain silent, and your attorney is going to be Mr. Chate. Okay. How many cycles, Mr. Howard?
46.
Okay, that's all I need to know. And he's currently in custody on a $40,000 bond. Ms. Morris, anything to add?
Yes, Your Honor. The state is recommending as conditions of his bond, ask that if and when he's released, he be placed on a 24-hour curfew except for legal, medical, or religious reasons. In addition to that, the state is asking for an ankle monitor, county paid, if possible. Stay away from Georgia Tech University, that's at 176 Fifth Street in Atlanta. No drugs or alcohols, and submit to random screens. In particular, this particular case occurred on the 20th of January of 2025. The offense was captured on videotape. Specifically, it happened on the Georgia Tech University campus, at the Delta Chi fraternity house. That house had video which captured the defendant walking on foot onto Georgia Tech campus, walking through the campus, and eventually getting near that Delta Chi house where there was a bicycle located along the rack outside the home. That bicycle had a lock, although it was not engaged, it was attached to the bicycle. The defendant was seen walking the bicycle from the campus, eventually riding it off the campus. Officers were able to basically identify him through previous incidents with Georgia Tech University. He had been previously trespassed from Georgia Tech University because there was a theft there. They were able to identify him not only through that previous incidents, but also probation officer who was able to identify him from a still photo that was obtained from that video. Based on, I know Your Honor heard the cycles that he had here, much of that has to do with theft-related incidents, as well as there are some potential drug related incidents in his past. We're asking for the bond amount remain the same as a surety bond, but add those conditions as well.
Mr. Shate?
Yes, Your Honor, I just asked for the lowest reasonable bond value for this particular case. He's already in custody on a $40,000 bond. My client is 56. He served in the Navy for 4 years before being honorably discharged. And he's been an Atlanta resident for 14 years, so he has ties to the community.
On count 1 is going to be 2,500. Count 2 is 2,500. Count 3 and 4 are 1,500. His total bond is going to be 8,000. That's going to be a surety bond. No further contact, to stay 500 yards away from all Georgia Tech property. And I didn't remember the name of the owner of the vehicle, but
That's Richard Crawford.
Richard Crawford. Okay. No contact with Richard Crawford. And his next court date is February 27th. And if there's any amendment to the bond, the court will seriously consider an ankle monitor at that time. But presently, I think I'm going to stay with the $8,000 surety bond. And the students should learn to lock those bikes. All right, thank you.
Next, we could go to position number 10, Mr. Rice.
Gregory Rice is accused of battery, family violence, and 1 count of battery from February 13th of this year, case 25 CR 784E. Mr. Rice, you've been advised of your right to remain silent. Your attorney is Mr. McLean. Any priors, Mr. Howard?
8. What we got? On probation out of Clayton County. Ag assault. Unauthorized possession of a prohibited item by inmate. 2023 probation. 2022 battery DV conviction. 2016 battery conviction. 2016 burglary 2nd degree conviction.
All right, thank you. Ms. Morris?
Your Honor, the defendant currently has a $5,000 total surety bond, $2,500 on each count. State is asking that that bond remain in place as is, but asking to add the additional conditions. One, we would like for him to be seen by a social worker. Through our communication with his mother, as well as the victim in this case, the state became aware that Mr. Rice suffers from some mental health issues. He has been formally diagnosed since childhood. The mother, he has been living with his mom at the incident location, which is 2905 Springdale Road here in Atlanta. The facts of this case, as alleged, is that the defendant and his living girlfriend, who was residing at that location, the 2905 Springdale Road, had met about a month prior to this, lived in that home with the mom as well as a cousin of the defendant, a Deontay Springdale. At the time of this incident, which was on the 13th of this month of February, the victim in this case decided she no longer wanted to be in a relationship with the defendant. She informed him of that. That made him angry. As such, he began to attack her. He punched her. He then got on top of her, grabbed her by her neck, and strangled her to the point where she said that she lost her breath and felt like she was going to lose consciousness. Eventually, the cousin Deontay Stegall intervened in this particular incident and had to pull the defendant off of Miss Asia Arnold. And during his attempt to pull the defendant off, he was physically assaulted by the defendant as well. Our office has been in contact with both the victim in this case as well as the mother, as I said before. Both said that they're afraid of the defendant. And the mom is saying she no longer wants him in her home. In speaking with her myself, she told me that she felt that her child needed, or the defendant needed, a long-term mental health facility, that he has not been on his medication for at least a month when this incident happened, and that the last time that she know that he had medications when he was hospitalized for his mental health issues. And she says the reason why he hasn't had that medication is because he does not have insurance to pay for it. And so the state is concerned that there's a serious risk to reoffend based on the fact of the criminal history, the lack of mental health compliance or ability to obtain it. Also, we do feel that there is a strong possibility that witnesses may be intimidated if he's allowed to return to that particular location. Mom did inform me that if he was not living with her, that he would have to seek a shelter, to her knowledge. So the state is asking that the bond remain in place with those conditions. And I think I may have said, I know I said a social worker, we're asking that he stay away from the incident location, no weapons or replicas based on his history, of course, no violations of the law, and no contact with Asia Arnold or Deontay Stegall, which is the cousin. According to both Miss Arnold and Miss Murphy, I think they were supposed to be on the Zoom today. If Your Honor could sound for them to see if they wanted to share, if they're available.
Well, I see Asia. So Miss Asia, if you are Asia Arnold, you are free to start your video and unmute if you want to add. And Deontay Steggles, all right.
Oh, Your Honor, if I may interject, because of what a layperson may not know the limits of certain things, why don't we do this as a breakout room because of what is probably going to get shared?
I just want to know whether they want to have contact with him. That's all.
Okay. Yeah.
Miss Arnold, which one is Miss Arnold?
Me.
All right, raise your right hand.
All right.
Other right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Do you and Gregory live in the same property?
Yes.
And are you comfortable with him being in the same property with you?
No.
All right. And does Deontay Stegall live in the same property?
Yes.
All right. All right, you can mute your screen. Thank you.
Your Honor.
All right. Mr. McLean?
Your Honor, my client obviously needs some resources. If he's not welcome at that home, then we're going to have to find him some resources. So we'll be getting a social worker visit to advise on housing, compliance, etc. Thank you.
Mr. Rice, you have a right to remain silent. Anything you say during this court proceeding, your statements can and will be used against you. If you decide to waive your right to remain silent, you could end up incriminating yourself.
Yes, I decided to waive my right.
What would you like to say?
I understand what they're saying and stuff. I do have a huge mental health disorder. I haven't been on my medicine and stuff like that. I was asking if it's numerous amounts of. I've been in programs before, and I was asking if it was possible that I could be able to go back to one of the programs that I have been in because they have helped me a lot with a lot of my treatment. It was on me to not take my medicine and stuff like that because certain medicines that I was taking, I was feeling as though that it wasn't helping me fully to the fullest, and I should have fully expressed that to my mother. My insurance, I don't have insurance that can help me, so she's right about that. I just want some help, ma'am. I just want help. That's all.
Okay.
I'm not trying to hurt nobody. I'm not trying to do anything like that. I just need help, and I'm pretty sure everybody knows that I need help, ma'am. And I have numerous amounts of programs that I have been to that have helped me with my mental health in the past before and stuff. And I would really like to go back to those programs. I'm not a bad person. I know I have a record. I know I have a record and stuff like that, but I'm not a bad person. I am a good person, as my mom knows that I do good things. I just mess up sometimes because of what's inside of my head and what I see or what's inside of my mind. And I'm just asking for another chance for me to be able to either go to a program or be able to have signature bonds so I can go to a program or something, please.
Mr. Rice, based on your record as well as the allegations set forth in the warrant, and also based on the victim's resistance to having you have any contact with them, on the battery family violence, your bond is going to be set at 1,000, and on the battery is going to be set at 1,500. Your total bond is going to be 2,500. This is going to be a surety bond. And then if you are still in jail, they will have a social worker visit you and consult with you with regards to options that you may try in order to help your situation. You are to have no contact with Asia Arnold and Deontay Stegel. You're to stay away from 2905 Springfield Road in Atlanta, Georgia. You will need to update the court with your new mailing address within 30 days of being released. If you do make bond, also make sure that you undergo or you continue with your MH treatment and that you're compliant with all requirements, including medication. Thank you. Your next court date, is February 27th.
What is a surety bond?
A surety bond means that you would have to either pay for the bond out of your own pocket or you go through a bonding company and they charge 10 to 15% of the bond amount. Thank you.
I can see in that right here. Your Honor, we can go to add-on number 1 on the calendar, Mr. Cormack.
Okay. Is Miss Lucia with us here? No? Okay. Position add-on number 1 is Devin Cormick, case 25 CR 0000787C. Mr. Cormick is accused of criminal trespass, cruelty in the 3rd degree, battery family violence, and battery family violence against an individual who's pregnant. Mr. Cormick, you've been advised of your right to remain silent, and your attorney is going to be Mr. McLean. Any priors, Mr. Howard?
I counted around 17. Got an open suspended license, open case out of Maryland, firearm possession with felony conviction, 2023 violent arrest, it was dismissed, 2020 assault dismissed, 2015 assault 2nd degree conviction, 2013 destruction of property conviction. This is out of state.
Okay. Miss Morris, Miss Allen, excuse me.
Thank you, Your Honor. This is an incident that happened on the 13th, so yesterday at 6090 McClure Road in Fairburn. Police there, South Fulton police were called about a domestic dispute. They met with the victim in this case. Her name is Precious Scott. She lives with the defendant and is 28 weeks pregnant. She reported that she was in a verbal dispute and he started to strike her multiple times in her face. Her face was noticeably swollen in the cheek area. The child of Mrs. Scott, date of birth 2019, was present and witnessed that altercation. Her initials are JS. The victim said she went to her car to wait for police after she called for help, and she watched the defendant put her belongings outside of their residence. We spoke to Mrs. Scott today. She reports that they're no longer in a relationship. She does say she feels conflicted because she's currently pregnant. She confirmed what the documents from police said, that the argument started because the defendant was leaving and she asked him where he was going. This angered him. He punched her multiple times in the face, and then they fell to the ground. She reported that he put his knee into her stomach. She also reported that sisters of this young man tried to intervene and get him off of her physically. She's concerned about going into preterm labor. We're asking for a $4,000 good bond, Your Honor. Absolutely no contact with Mrs. Scott or any of the children present, JS specifically. We'd ask for a family violence intervention and no drugs, alcohol, or weapons. We'd also ask him to stay away from that location.
Mr. I think it was
Excuse me,
Mr.
the victim,
McLean.
when we followed up with her a second time, we actually were told that she is being treated right now, and they are trying to stop her because she went into preterm labor as a result of this incident, Your Honor.
I see. Mr. McLean? I'm sorry, you're on mute.
I believe that's going to be Mr. Chatai. Is that correct?
I'm sorry, Mr. Chatai, is this your client? Devin Cormack. I'm sorry, you're on mute, sir. There we go.
Yes, Your Honor. Sorry, I had his notes here because he was added on a bit late. Could the state repeat the recommendation, please?
Yes, we're asking for a $4,000 good bond, no further contact with the victim, Precious Scott, or the child, JS. We'd ask for a family violence intervention and no weapons, drugs, or any alcohol. It's unclear. This incident location is the defendant's family's home, and his family had to intervene to get the victim off. So as long as there is confirmation that the victim has somewhere else to live, we're not going to ask for a stay away order there, but to stay away from anywhere this young woman, Mrs. Precious Scott, lives or works. She's currently in the hospital.
Right. So my understanding is that the complaining witness in this case lives with her aunt and grandmother at a different location. So I don't think a stay away would be necessary here. I would just ask for the lowest surety amount that's reasonable for this case, Your Honor. My client's 38. He's lived in Fairburn for the past 3 years. He has his closest family members living here in Georgia. He's a high school graduate and is an entrepreneur. He just started a 30-employee business last week. It's called New Heights. And he takes care of his grandfather at home who has colon cancer and also looks after his mother. And with that, we just ask for the lowest reasonable bond value.
All right. On the battery family violence against a female who's pregnant, that's going to be $3,500, and that's going to be a surety bond. On the battery family violence, count 3, that's going to be $2,500. The cruelty is going to be $1,500, and the criminal trespass is $1,000. And that's 2, 3, 4, 5. That's a $5,000 signature bond through pretrial services, level 2, with a requirement that he enroll in a domestic violence intervention program within 30 days of being released on bond. He's to have no further contact with Precious Scott, with her child, JS, and he's to have no contact with the child that she has with him in the eventual event that the child is born. If Mr. Cormack wishes to have contact that the child he shares with Ms. Scott, he would need to file a legitimation action and obtain a court order to establish visitation, custody, and child support. No illegal drugs, no alcohol, and no weapons. He is allowed a one-time visit to the location at 6090 McClure Road in Fairburn, Georgia. The officer must verify that Precious Scott and her child do not live there. And if it's confirmed that they do not live there or continue to reside there, then he may return to the property. Otherwise, he'll need to stay away from the location until she vacates the premises, and he would need to update the court with his new address within 30 days of being released. So this will be a 8,500 split bond. Did I get that right?
Yes.
Next court date is February 27th.
But can I have a question? She's having twins and I won't be able to be there for the birth.
You are not allowed to have any contact. You have to stay 200 yards away from Miss Precious Scott, her child, all her children, even if she shares them with you. You'll need to file a legitimation action once the child is born.
Next, we go on to position number 2 on the add-on. Mr. Roth. Ruth.
Yes, it's pronounced Ruth.
Okay. Jacob Ruth is case 25 CR 0000788G. Mr. Ruth has the following traffic matters stemming from a January 25th, 2025 incident. Driving under the influence of alcohol less safe, reckless driving, driving while license suspended or revoked, and failure to maintain insurance. Mr. Ruth, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Any priors, Mr. Howard?
12. Got an open felony in open case in Superior Court, false imprisonment, criminal damage to property, on probation for reckless driving out of the city, 2024 DUI obstruction arrest, another 2024 DUI, 2015 reckless driving conviction. That's it.
Ms. Morris?
Yes, Your Honor. Mr. Ruth currently has a total $13,000 surety bond. With a breakdown of the following, he has $10K on the DUI and $1,000 on the reckless driving, the driving on suspended license, and the failure to maintain lane. The state is asking for an increase in the bond amount on the reckless driving from $1,000 to $5,000 to give him a total bond of $17,000 surety. And that's based on the following facts. In looking at his record, Your Honor, he was charged in 2016 with DUI that was reduced to a reckless driving that was here in Atlanta. He also was charged with DUI and fleeing and eluding in Whitfield County. That was reduced to reckless driving, which he pled to. He has a DUI conviction out of Gwinnett from 2006. He is currently out on bond on a DUI from November 5th of 2024. He also has a 2021 driving on suspended license conviction. The state feels that if and when Mr. Ruth is released, because of his inability to not drink and drive, he poses a significant risk to reoffend, as well as he's a danger to the public. It's just a matter of time before Mr. Ruth injures and or kills someone based on his inability to not drink and drive. So we're asking for that $17,000 good bond with the following conditions. We're asking that he have no driving until his license is restored, enter and comply with an alcohol treatment program within 30 days of his release. We also, although this is unconventional, we would ask that his car be fitted with an ignition interlock within 30 days of release as well. Of course, have no alcohol or drugs, as well as random screens. And the facts that give rise to these conditions, as well as the request from the state, as alleged, are that at about 6 p.m., as you stated, on the 25th of January of this year, this was on 447 Arnold Street, a concerned citizen called 911 and reported a male that was passed out behind the wheel of a running vehicle. When officers arrived, they found Mr. Ruth behind the wheel of that vehicle. He was indeed passed out. And he was draped across that steering wheel. They were able to wake him up. They asked him if he had a medical emergency going on. He said no. Officer was able to see a half empty natural light beer can inside the cup holder. Once they started speaking with Mr. Ruth, they were able to see that he was visibly intoxicated. He had slurred speech. A check of his license revealed that he had suspended license, and that suspended license was due to that November 5th DUI that he was charged with, where there was a refusal to blow. And so in addition to that, they did see that this insurance was not active on his current vehicle. And so based on his risk to reoffend, his danger to the public, as well as all the criminal history that I reiterated to the court, we're asking for a total bond of $17,000, with the only change being on that reckless driving to include 5K, as well as the conditions that I laid out before the court. Nothing further from the state, Your Honor.
All right. Mr. McLean, anything to add?
Your Honor, Mr. Ruth is 47. He is from Georgia. He does not believe that he'll be able to get his car back. I think it's an impound. He's not going to be able to afford to get it out at any rate anyway. He had asked the court to consider as low a bond as possible under these circumstances. I told him it probably would not be a signature bond. We would ask the court to consider something in the neighborhood of $5,000 total. That should be sufficient to ensure his return to court. He has a good address, the Metawan Circle in Smyrna. He's a senior project manager for the last 22 years. He's got a BS in mechanical engineering and civil engineering. That's construction management that he does. So he's been a senior project manager for a long time. He obtained those degrees in Missouri. Your Honor, he does intend to get treatment. Appropriate conditions along those lines would be would by definition, as I said, be appropriate. But Your Honor, we would ask Your Honor to consider something less expensive to get out.
Well, technically speaking, this is his 4th DUI in 1 year. And if extraordinarily, I'm more inclined to no bond at the present time. On the DUI, it's going to be a $10,000 cash bond only. Reckless driving is $2,000 cash bond only. The driving while license suspended is $2,000. Failure to maintain insurance is $2,000, and that's a $4,000 surety bond. This is a $10,000, $12,000, $16,000 split bond. And once Mr. Ruth steps out of the jail, before he even steps onto the tarmac, he has to be equipped with an ankle monitor to be paid for at his expense, where we will monitor his events. He's subject to a curfew every day from 6 p.m. to 6 a.m. And he is prohibited from driving any vehicle. Even if DDS gives him a limited permit, according to this bond, he's not allowed to drive. He can find someone sober and of age and with a valid license to drive him, but he himself has lost the privilege to drive a vehicle until further order of the court. Thank you. Next court date is February 27th. He's clearly a candidate for DUI court, Mr. McLean, if he ever agrees to that. Nope, I'm done. Thank you, Mr. Ruth.
Your Honor, the Spanish interpreter is on it. We could go ahead and do a breakout room with her and Mr. Chai, room 2.
Okay. Who's got Mr. Ortiz Gomez?
I'm available, Your Honor.
Okay.
Go to the breakout room if Mr. Ty has something else to deal with right there.
All right, Mr. Howard, what's his pretrial look? What's his GCIC look like?
Who was it?
Position 8.
What's the name?
He's the bind over.
Third arrest, 2024, driving without a valid license. 2022, driving without a valid license conviction.
Okay, and does he have a hold by ICE?
He does.
He does?
Okay.
Oh, okay. I didn't know.
All right, has Mr. McLean gone into the breakout?
No,
he's right there. All right. As soon as courtroom 2 accommodates, Ms. Lucia, thank you for being here. We're going to put you in a breakout as soon as Mr. Ortiz Gomez is available.
Here, Your Honor.
Yes, Your Honor.
Oh, are you all comfortable talking with him in courtroom 2, Mr. McLean?
Well, I'm not sure what the courtroom, I'm in a remote location. I'm not sure what the courtroom 2 situation is in terms of people being, what,
I think that's the last case, and I think they can remove Mr. Ralph as soon as possible. Is that
That'd be
correct, Deputy? All right. Miss Grace, can you place Miss Lucia, courtroom 2, and Mr. McLean into a breakout?
Yes, ma'am.
All right, Mr. Chatay, Miss Allen and Miss Morris, while we're waiting. Position number 1, Joshua Bass, was a 2,500 signature bond through pretrial level 1 and a stay away from Autry Middle School, 500 yards away. Position 2, Carrington, that was a 2,500 surety bond with a social worker visit, and reset date is February 27th. Position 3, Dodson, that's going to be a 3,500 signature bond through pretrial with an FBIT requirement, no violent contact, and continue with MH treatment and medication. Position 4, Harris, was a 1,500 signature bond through pretrial level 1. Position 5, Hines, that is a split bond, $8,000 split bond. Reset date is February 27th. Position 6, McGee, is a 2,500 signature bond through pretrial level 1, no violent contact with the alleged victim, and 12 anger management classes within 60 days to enroll in them.
Hey, what's the level for McGee?
For McGee, it was level 1. Position 7, Keith Oliver, that's a $8,000 surety bond. And reset date is February 27. Does he have a probation hold?
That's a guy that been here for a minute. Hold on.
The Georgia Tech Trek bicycle thingy. Ms.
Hold
Allen?
on.
I thought there was some conversation about that, but I'm not sure. Well, position 8 is in conference. Okay. Position 9, Tariq Price, is $1,000 signature bond through the jail. Position 10, Gregory Rice, that's a $2,500 surety bond with a social worker visit. Reset date February 27th. Position 11, Satterfield, that's a $2,000 signature bond through pretrial, level 1, 2 anger awareness classes. 12, Nahisha Smith, is a $1,000 signature bond through pretrial, level 1. 13, Theodore, is currently pro se, and bond is set at $4,000 surety bond. Reset date February 27th. 14, Allison Victim, that's a 2,500 signature bond through pretrial, level 2. And then on the add-ons, Devin Cormack, that's a 80, I think it was a 8,000 or 8,500 split.
8,500.
8,500 split, okay. Reset date is February 27th. And then Jacob Ruth is going to be a $16,000 split bond, 12,000 of which is cash bond only, and no driving and curfew, and no alcoholic beverages, no illegal drugs. And that's the case I think is maybe a candidate for DUI court if he is so inclined. All right, we'll just be in a brief recess until Mr. McLean and Mr. Ortiz and Ms. Lucia come back to the main session. Thank you. Mr. Jordan, did you have a question?
Oh, did the sheriff deputies pull Mr. McGee for the plea?
Position 6, Mr. McGee?
No, O'Garis McGee, that's the one you wanted to reset for today.
Oh, yes, that's right, thank you. And Miss McLeod has been here also, but we haven't seen hide or hair of O'Garis McGee. Well, I can't ask the deputy. Would they instructed to bring Mr. McGee?
I sent them the calendar yesterday, and then I talked to Sergeant Glanton today. So they were supposed to bring him to court.
All right, we'll ask courtroom 2, unless you can call in down there and just see if the deputy is there. 22392. Thank you.
Hey, number 6, the contact was no further contact.
It was no further violent contact.
Wow. All right. Thank you.
On Mr. Oliver, he is currently on probation and just had a revocation in a 23 SC case.
Okay. So there is a revocation right now?
There just was.
Okay.
He's supposed to be reporting every single day. Let's see, he's got open shoplifting probation case.
No, I'm just looking at the warrant and I'm wondering whether there was an intent to file a revocation of his probation, so.
I don't see one yet, but
Okay.
he's supposed to be reporting there every day, so I imagine that it will happen shortly.
Okay, so we'll just wait till Mr. Ortiz appears, and we're also waiting on Mr. McGee. So Mr. Jordan's looking into that. That's supposed to be a plea hearing from Thursday.
Ms. Okake will be handling that. I am looking at a gentleman that was would you use your expert
Were you addressing
Yes.
Ms. McLeod or me? Okay.
Your Honor, I just wondered if you would look something up and tell me if you see something different than I see. I have a gentleman that I was just sent today to review Benjamin Flowers. I have just accused his cases. It looks like it was erroneously put on the felony docket today, but I do believe he also has felony cases. So I think I understand why people might have been confused.
Do you have a jailing number or a case number?
His booking is 250-2590. It looks like he was just arrested on February the 11th for a shoplifting, which was just created and accused by us. I think it was on the felony docket this morning by accident. But he also has a open 25 PI case.
2 of them, 112 and 113. And a College Park hold. So which one is the is not supposed to be in felony court?
Right. Let me see. I think, well,
So he's got an incident from February 11th, 2025.
that's it. But it's not listed on the charging screen. It's in the documents. And all the documents have 211 on them. Well, there's one 212. So it is the 6-page document, electronic warrants, Dollar General.
So according to this, it's misdemeanor theft by shoplifting and misdemeanor willful obstruction. So that should be with us.
Yep. I charged it. I just was unclear. I was trying to figure out if something had been heard in felony court and a decision had been made and we ended up with another one of those cases. It wasn't clear to me in the email that I got. So I wanted to make sure.
Are you talking about Flowers?
Yeah. Do you see anything, Mr. Jordan, about any other case besides he's got multiple cases, and so I want to be sure we're capturing what was sent to us.
I don't know if he was mistakenly put on the felony count, but he had felony first appearance on 12. Well, it looks like 12
Okay.
on 24 PI 001129 with the same incident date, and that charge, the case was bound transferred to state court.
And what is the end of that number? 00?
1129.
Right. Okay, so we've charged it. He's also got two other.
Yeah, he's got a couple cases there.
Yeah. Okay. So we've charged it. Was he given a bond on that?
They did. Hold on.
But can he be added to the SAP?
We can put him on SAP.
Does
So
that
he
make
got
sense?
5,000 surety on the theft by receiving that was reduced to a misdemeanor with a 10% bond, and then $1,000 on a willful obstruction. I'm sorry. Well, he's got two cases. Hold on a second.
Yeah. I'm not
Now I'm off.
usually so confused, but I'm confused.
Well,
Maybe
he
I'll
was,
get
he was given a PI number, and now because they've been reduced, we're waiting for them to be amended to a CR number and then be placed. So if they're amended to a CR number, Mr. Jordan, can we go ahead and put him on the February 27th SAP calendar?
Well, I think they just filed the case, so we have it. We'll put it on the SAP count.
Okay.
So he has a CR case number with the same incident date.
Yeah,
that
I filed
he
it
filed.
today. I just
Right.
wasn't sure because thank you for your help. It's
So
Friday.
the drawback, Mr. Jordan, is that if the PI cases have been reduced to misdemeanors and then Miss Allen has also accused him, he could be looking at multiple duplicate charge cases.
I think we're good, Judge, because they transferred their case to state court.
Okay, so as long as they're consolidated with the accusations filed by Miss Allen, then that should be good.
I see where the transfer is on 1129, the one ending in 1129. I was worried about the open theft by receiving being confused with what we have. So I see it.
Oh, so that one has a 25 PI 001130.
Yep.
Check that one out. I didn't look at that case.
So I see it's literally a theft by shoplifting and obstruction that has a PI number and they're both misdemeanors. So it was a mistake. And he does have a bond and an order to transfer it. So we've now charged it. Thank you for your help.
Okay, so just waiting on Mr. McLean and for Mr. Ortiz's case. All right, thank you.
And Sergeant Glenn said he's going to get Mr. McGee.
Thank you.
Okay.
And what SAP can you put Mr. Flowers on? Can you put him on Tuesday?
February 27th. Everything else is stacked.
Got it. Okay. Thank you.
He may be on the 20th. Let me look real quick. He's on the 25th calendar. SAP.
Ms. McLeod, they are trying to bring your client over. So, Mr.
Yes, Your
Doyle,
Honor.
I'm waiting too.
Yeah, he's been calling me from the jail. He's pretty anxious to take his plea. And he told me they haven't come to get him yet.
Okay, yeah, we set the notice in yesterday, so I'm
I
hoping.
did receive it.
Okay, all right, let's cross fingers and toes. Thank you.
Oh, here he is. They just brought him.
Okay. Mr. McLean, all right, let's address the plea first. This is State versus Ogarius McGee. Mr. McGee has 4 outstanding cases at the present time, and they are as follows. 23 CR 4765B, accused of simple battery from February 15th, 2023. 23 CR 4766B, accused of terroristic threats and acts and simple assault family violence from January 7th, 2023. 24 CR 1008B, accused of simple battery family violence from February 26, 2024. And the 4th case is 24 CR 7673B, accused of simple battery family violence from November 15th, 2024. Mr. McGee, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Maureen McLeod. On courtroom 2, please unmute. Mr. McGee, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Ms. Mokeke or Ms. Allen, are you all ready to give your recommendation for these 4 cases?
We are, Your Honor. The state's recommendation for 23 CR 4765B is 12 months probation, no further contact with Antonio Thomas, stay away from 4050 Morgan Road in Union City, remain compliant with any current mental health treatment plans, no firearms. The state's recommendation for 23 CR 4766B for count 1, the terroristic threats, is 12 months to run concurrent with count 2. The state's recommendation for count 2, the simple assault, is 12 months probation, stay away from 4050 Morgan Road in Union City, no further contact with Olin McGee, remain compliant with any mental health treatment plan, no firearms. The state's recommendation for 24 CR 1008B is 12 months to serve 242 days, credit for time served 121 days, balance probated that he undergo an ADET, 40 hours of community service, no further contact with Olin McGee, that he do an FVIP and stay away from 4050 Morgan Road, of course, no firearms in his possession. The state's recommendation for 24 CR 7673B is 12 months to serve 184 days, credit for time served 92 days, no further contact with Olin McGee, stay away from 7882 Sonoya Road in Fairborn, an FVIP, remain compliant with any current mental health treatment plan, no firearms. All 4 of these cases are to run concurrently, Your Honor. I would ask the defense to stipulate to venue, factual basis, and identification.
You so stipulate.
All right. On case position 1, that was no further contact with Antonio. What was the last name?
That was no further contact with Antonio Thomas.
Thomas, okay. And that was Sonoya Road. What was the street number?
The first one, Your Honor, was a different location, wasn't it?
No, everything was 4050 Morgan Road with the exception of position 4.
Yes, position 4 was 7882 Sonoya Road, and that is the Wyndham Hotel.
All right. Ms. McGee, Ms. McLeod, does your client stipulate to the factual basis, venue, and ID for all 4 cases? And does he accept these terms?
Yes, Your Honor, he does.
All right. Oh, and one other thing, Ms. Mukeke, position number 4, that was credit for 92 days and to serve how many days?
Credit for 92 days to serve 184 days.
Okay, thank you. Mr. McGee, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in all these cases?
Yes, ma'am.
Are you satisfied with your legal services?
Yes.
And are you prepared to enter a plea to all these 1, 2, 3, 4, 5 charges
Yes.
freely, willingly, and voluntarily?
Yes, ma'am.
Well, you and your attorney have spoken. Do you understand that if you plead guilty to these charges, you would have to give up your constitutional right to a trial? You will not be able to go back to court to confront your accuser, challenge the evidence brought against you, have your attorney help you to present your arguments, defenses, and mitigating factors, as well as you waive your right to have the prosecution carry its burden to prove all these charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to simple battery from February 15th, 2023?
Guilty.
How do you plead to terroristic threats and acts and simple assault family violence from January 7th, 2023?
Guilty.
How do you plead to simple battery family violence from February 26, 2024?
Guilty.
And how do you plead to simple battery family violence from November 15th, 2024?
Guilty, Your Honor.
All right. You'll be released within 24 hours, but you must report to probation on Tuesday, February 18th, before 3 p.m. And
I
that
believe he has a hold for Union City.
Oh, he has a hold? Okay.
Yes.
Well, whenever you're released from your hold, then you're to report to Fulton County Probation within 48 hours of being released.
Yes,
That's
ma'am.
when your probation will begin. For position 1, your sentence is 12 months probation, no contact with Antonio Thomas. Stay 200 yards away from him, and you have to stay 200 yards away from 4050 Morgan Road in Union City. You have to comply with all MH treatment and medication and not possess and own firearms. On position 2, terroristic threats is 12 months concurrent with count 2. And on the simple assault, 12 months probation. Stay away from the Morgan Road location. No contact with Olin McGee. Again, comply with MH treatment medication and no firearms. On position 3, your sentence is 12 months to serve 242 days and credit for time served 121 days. Again, you'll be on probation. You'll need to complete an alcohol and drug evaluation within 15 days of reporting to probation. Complete 40 hours of community service at any nonprofit agency at a minimum rate of 10 hours per month. Have no contact with Olin McGee. You also have to enroll in a qualified domestic violence intervention program within 30 days of reporting to probation, and you are to complete all 26 classes. Again, stay away from the Morgan Road location. And finally, on the position 4 is 12 months to serve 184 days, credit for time served 92 days, no contact with Olin McGee. Stay away from the Wyndham Motel at Sonoya Road in Fairburn, Georgia. Comply with all MH treatment and medication and no firearms. That concludes your sentence. Thank you.
Thank you, Your Honor.
All right, Mr. McLean and Ms. Lucia, moving on to position 8 on our expedited accusation calendar. Ms. Lucia, this is State versus Luis Ortiz Gomez, charged with driving while license suspended and or revoked and speeding.
Esta es la acusación del Estado en contra del señor Luis Ortiz Gómez. El cargo es manejar con una licencia de conducir suspendida y manejar a alta velocidad sobre el límite.
This case is a bind over or transfer from the city court with the same charges.
Este cargo vino de una corte, de un tribunal de la ciudad bajo los mismos cargos.
And his new state court case number is 25 CR 782G.
Y el nuevo número de su caso con el Estado es 25 CR 782G.
Right. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Michael McLean is your appointed counsel.
Usted tiene el derecho de permanecer en silencio. Cualquier cosa que usted diga puede y será usada en contra suya. También tiene el derecho a tener un abogado y el señor McLean es el abogado que le ha sido asignado como defensor público.
We've already heard his criminal record history. Miss Allen, what's the recommendation?
Antes de escuchar el historial criminal, le preguntan a la fiscalía, la señora Allen, cuál es la recomendación.
Your Honor, based on the prior driving without a license cases and the defendant going 93 in a 65-mile zone on Georgia northbound, we're asking for a $2,000 surety and no driving without the proper documentation.
Su señoría, basado en los casos previos que tiene el acusado de no tener licencia y de haber estado manejando a 93 millas por hora en una zona de 60 millas por hora, nosotros recomendamos una fianza de $2,000.
Right. Mr. McLean?
Your Honor, Mr. Ortiz Gomez is 24. He has obtained a 6th grade education. He works as a cook at a restaurant in the northern part of Fulton County, and he's done so for the last 3 years. As far as the stability of his mailing address and the usefulness and efficiency of his mailing address, it turns out I was able to, in the last few minutes, Google things, and I believe letters could be delivered safely to the address that he gave me. And at any rate, I know the names of his supervisors at the restaurant that he works at. And it's a going concern that has very good food.
All right, sir.
So I don't think there's any trouble with communications or actual ability to know about future court dates. The only real problem here as a practical matter is the hold. So I warned him that unless that hold disappears, he's going to be in our SAP in a couple of weeks. But we would ask the court to consider a signature bond in this matter, Your Honor, or the lowest bond possible for this matter. Thank you.
Go ahead, Miss Lucia.
Su abogado indica que usted es un joven de 24 años de edad con una educación hasta el 6º grado. Trabaja como cocinero en un restaurante en la parte al norte de Atlanta y ha estado trabajando ahí por 3 años. Tiene una dirección estable, el señor chequeó en Google y la dirección que nos dio es una dirección donde parece que sí puede recibir el correo. Entonces, pide esa fianza para este caso, pero obviamente la parte práctica es la orden que tiene de la otra orden que existe.
Count 1 is going to be 1,000. Count 2 is 1,000. This is a $2,000 surety bond. No driving unless he has a valid driver's license, adequate insurance, and proper registration. And he is to be released to any pending holds that are currently existing. Thank you. Next court date is February 27th.
El siguiente día de su corte, bueno, la jueza lo que ella determina es que su fianza va a ser $1,000 por cada acusación. Eso es un total de $2,000 asegurados. Una orden de no conducir sin una licencia de conducir válida, más seguro y registración. Y su próxima fecha de corte es el 27 de febrero.
All right, that concludes our calendar. Thank you so much, everyone. You all have a great weekend.
What was that bond?
Gracias.
$1,000 surety on each count.
Okay, thank
Y
you.
eso es todo el calendario. All right, you folks have a great Valentine's Day and a nice weekend.
You too, Miss Lucia. Miss Lucia, actually, I thought you were going to stop Mr. McLean, but I guess you're used to him talking and talking and then being able to interpret everything.
Yes, plus I take notes during the interview, Your Honor. So when he's saying, whenever he goes on, I just check the notes that he's talking about. So I just read over them, basically.
Because she normally stops people in between. So, Mr. McLean, you're clearly a special favorite for her. So.
Yeah.
All right,
Doesn't
everyone.
say that
Have
to
a,
nada.
all right, everyone. Hope you have a good, lovely Valentine's, and I'll see you next week. Take care.
Thank you so much.
Sure.
Bye-bye.